Meta faces massive cut to $167 million win over WhatsApp. But wait, how can a party win millions in court and then a judge cut it down almost all of it? How can that happen? Let's unpack this shocking legal twist to see what that means for litigation and also for your bar exam. Hi future lawyers, it's Vinicius Costa. I'm a dual qualified lawyer in California and Brazil. I passed the California bar exam on my first attempt, and today we are mixing law in the news with bar exam strategy. In this recent case, published last week, Meta, parent company of WhatsApp, won a huge $167 million punitive damage verdict against NSO Group, an Israeli cybersecurity firm accused of hacking 1,400 WhatsApp users through its spyware, targeting journalists, activists, and government officials worldwide. We have the order here, so let's take a look. Okay. You may see that there are several topics here in this document that are not relevant for this video, so let's concentrate on the order referring to the motion for remittitur or new trial. Okay, here it is. Alright. Here's the twist. The federal judge just reduced that amount to roughly $4 million, saying the original verdict was too excessive. So what just happened here, and how does this connect to your bar exam? This is a perfect real-world example of two procedure tools every bar candidate must know: Remittitur and Additur. These are legal procedures related to adjusting jury verdict amounts. Let's recap a bit of civil procedure here. Okay, after the verdict is issued, the losing party has several possible options. They may accept the judgment as it is and pay whatever was decided. They may move to amend the judgment if a non-substantial error was included in the decision. They may ask the judge to enter a judgment notwithstanding the verdict, that is, to decide that no reasonable jury could have reached that conclusion. And the party may do that by filing a renewed motion for judgment as a matter of law. Or, in California, a motion for directed verdict. They may appeal. They may move for relief from the judgment. Or they may move for a new trial. And remember, for bar exam purpose, a new trial is associated with material errors. If the party moves for a new trial, the judge may take several actions. The motion for a new trial is the key procedure tool that allows the court to revisit issues such as excessive or inadequate damages. In this context, the judge has discretion to either grant a full new trial or to offer a conditional one through the doctrines of Remittitur and Additur. Remittitur occurs when the judge believes the jury's award was too high, such that it shocks the conscience. In this case, the judge may reduce the amount and give the plaintiff the option to either accept the lower figure or go through a new trial. And keep in mind that remittitur may occur both in federal and state courts. Additur, on the other hand, is the mirror image. The judge believes that the award was too low, and for that reason increases it. In this case, the judge gives the defendant two options: accept it or face a new trial. But remember, Additur is allowed only in state court. An easy way to remember is that remittitur remembers reducing the damages, both in state and federal courts, and Additur remembers adding more amount, adding more value to that award. For this reason, we are including remittitur as reducing and Additur as adding. It is also important to remember that both remittitur and Additur are available only when a motion for a new trial has been filed. They are not standalone remedies, and remember that they are both alternative for a new trial. Okay, so let's pause for a moment and recap our WhatsApp hack case. In that case, the judge reduced the $167 million punitive damages award through Remittitur. Why? Because the court found that the ratio between punitive and compensatory damages violated constitutional due process limits established by the U.S. Supreme Court. Under that precedent, punitive damages generally can't exceed 9 times the compensatory award, unless the defendant's conduct was exceptionally egregious, which wasn't clearly the case there. But don't worry about that for now. It's more relevant to the case itself than to your bar exam. What you should focus on is the judge's ability to reduce that amount on his own. Thus, under Remittitur, plaintiffs can accept that reduced amount or face a new trial on punitive damages. And here's a final question for you to practice those concepts. Let's take a look. A state university professor filed a federal lawsuit against her employer alleging that the university violated a federal employment discrimination law by denying her a promotion to department chair. She claimed that this decision caused both financial loss and significant emotional distress. At trial, the evidence showed that the professor's lost wages and benefits totaled no more than $20,000. As for emotional harm, the only supporting evidence was her testimony that she experienced stress and had difficulty sleeping for a short period after learning she was passed over. The university objected to the judge's instructions on damages, arguing they allowed the jury to award excessive compensation. The objection was denied, and the jury awarded the professor $600,000 in total damages. The university then filed a motion for a new trial. Should the court grant the university's motion for a new trial? What do you think? Let me know in the comments. That's the key takeaway. Those doctrines let the judge fix an excessive or inadequate jury award without restarting the whole case. Now, if you want to go deeper into how motions for a new trial work, a judgment notwithstanding the verdict, and appellate review work, including California-specific distinctions that often appear in essays and multiple-choice questions, all of this is fully explained in our Aureus bar prep materials. You'll find detailed charts, quick reference tables, and practice questions that turn complex doctrines into easy memory hooks. Because remember, real lawyers don't just read the news, they understand the rule behind the headline.